I'll frankly put it to you. I felt that your client basically was saying, woman, you're not going to obey me, kind of thing. And then this is what happens. That's it. And I'm going to tell you, Mr. Friedman, I got that from the first hearings on the first case. Your client did not acquit himself very well before me. Stephen Gently versus Amanda Rain.
For the plaintiff, Your Honor.
Hello. Thank you. All right, where are we on this case?
Your Honor, this was a put over from last week with there was some question about the plaintiff being the owner of the property or
yes
not. So we have an amended complaint that we filed that includes the original plaintiff as well as his parents who own the property. And they also.
Did you get a copy of the amended complaint?
It was mailed to her.
Okay. So who was the rental agreement with?
She never had a rental agreement with anybody.
Well, I mean, there would have been some oral agreement.
No, she was living with the plaintiff. The plaintiffs.
Not mother and dad, but the other plaintiff. All right. All right. What do you have to say to this, ma'am?
So, Your Honor, I know we've been here a few times over this, and it's been the same thing. His parents, he filed the, as you know, I'm not a lawyer, but he filed the
Complaint or the notice to quit?
He sent me with the original complaint months ago stating that he had a lease, but his lease expired back in 2010. And I'm good friends with his mother because him and I have known each other since we were 14 years old. And we were in a relationship, and I've lived with him for over 5 years and always paid my rent, always paid my bills. There was a domestic disturbance that started where he threatened me and I had to call the police. And therefore, he decided to not be at the house as much. And once that started, I tried paying rent to him and he declined it. I have messages of it saying, hey, here's your rent, come get it. And he was like, nope, I don't want it. And then eventually he started court proceedings saying that he was the landlord tenant, and it wasn't. He doesn't have a current lease, and his attorneys keep saying that he does when he doesn't. I have a copy. His last lease was in 2010. And then his mother never gave me a lease. And I just spoke to his mother not too long ago, and she goes, I really hope you guys can work this out. I don't want to do an eviction, all this other stuff. And it's still, he keeps continually bringing me back to court over this. And I have lots of messages where I text him saying, you know, we've been through a lot together. Let's work this out. I need time to move and find something. As we know, rent right now is $2,000 a month everywhere. I'm like, I need time to save money. I can pay you. And we have a dog together, and he's bedbound. Stefan has not been there one time to visit him. Anything. So I've been paying for medications, constant care of him. And so now I'm worried about, he's trying to evict me, but I'm trying to work things out just to get time. Like, I want to move. I don't want to be there. And I agree, I want to move.
When was this domestic?
Your Honor, there was no charges, and believe me, that this is a smoke or.
Well, I don't know that that's going to be true.
Okay, well,
they were here before,
and it's not a divorce case.
I understand it's not a divorce case, but I also have a certain policy. I mean, people are living together and they're trying to move out. I mean, this is the second case, I do believe.
This is.
And the first case, and I don't think you were involved, Mr. Freeman, it was clear to me what the heck was going on. The one thing I didn't know about although I suspected was happening, was the domestic disturbance. That's why I'm just trying to get a framework here. I don't think, given what I saw in the first case, that it is entirely just a smokescreen.
Well, I think YPD might disagree with you, but
Well, I don't, Mr. Friedman, I don't care. I mean, sometimes domestic charges aren't filed. That doesn't mean that there's not a domestic.
okay.
And if there's a domestic that happens, in particular where the parties have been together and all of a sudden, and I'll frankly put it to you, I felt that your client basically was saying, woman, you're not going to obey me, kind of thing. And then this is what happens. And I'm going to tell you, Mr. Friedman, I got that from the first hearings on the first case. Your client did not acquit himself very well before me.
Okay, Your Honor, I understand that he didn't come off very well. I get it. But at the same time, the property's owned by his parents. He's there under a month-to-month lease. He's been there for years, 10 years. His parents have given him authorization to bring this action. I have a signed statement from the parents that he has the authority to bring this action. However, they have signed or allowed me or approved for me to file an amended complaint in which they are the plaintiffs. So I have a situation where the owners of the property are requesting that she be, that their tenancy be terminated and she leave.
When was the domestic?
The domestic was in, I believe it was in June over, if I can't remember the exact date in June, but there was about 7 officers that showed up because he spit in my face and raised a hot greasy pan to me. And I served that hot greasy pan to me and said, you're going away for a long time. And he wouldn't, the argument started because our dogs were sick and he wouldn't put the air in and it was 95 degrees in the apartment. And I said, I pay rent, I pay for the utilities, please install the air conditioning.
Okay.
And he started
I don't-
screaming at me.
And ma'am, how much time did you need?
Honestly, Your Honor, I would like to get 90 days, but I don't know how the law.
Okay, that's not gonna happen.
Okay.
What's the soonest you can get out? You wanna move?
I do 60 days.
For the length of relationship and everything else, how long are they willing to give her, Mr. Friedman?
End of February.
There really isn't an issue for me to try and discuss.
What we
it
just
with a
witnessed
grant
is a
judgment
perfect
for
example of how
possession.
personal relationships can spill
On the
over into
termination
legal
phase,
territory. And once they
but
do,
the writ will
emotions
issue March
rarely help your
13th,
case.
2000.
At the center of this dispute is not simply a landlord-tenant disagreement, but a former couple whose shared life has now been dissected in front of a judge. The defendant claims years of rent payments, emotional investment, and responsibility for a shared home and even a shared pet. The plaintiff's side insists there is no valid lease, no continuing tenancy, and full authority from the property owners, his parents, to remove her from the residence. The judge's questioning reveals something critical. This courtroom has history with these two. Prior hearings, prior conflicts, and now the emergence of domestic disturbance allegations. The court is not ruling on who was right or wrong in their relationship, but those events still shape the judge's understanding of credibility and power dynamics. When the judge acknowledges the possibility that domestic incidents do occur even without criminal charges, it signals that the court is looking beyond paperwork and into the real-life behavior of the parties. From a legal standpoint, the core issue is simple. Who holds lawful possession of the property? The plaintiff's attorney clarifies that the parents own the home and have now formally joined the complaint. That removes ambiguity about ownership authority. Once the owners request termination of tenancy, the court's options narrow considerably. Emotional arguments about shared history, caretaking of a pet, or past payments may explain hardship, but they do not override property rights when no valid lease is proven. The defendant's request for 90 days to move is understandable from a human perspective. Rising rent costs, limited savings, and personal instability are real concerns faced by many tenants. However, eviction courts operate on defined statutory timelines. The judge's response makes it clear. While empathy exists, the law sets limits. Ultimately, the court grants judgment for possession, meaning the property owners regain legal control of the home, while scheduling a separate rent hearing to determine any outstanding financial obligations. This ruling closes the tenancy chapter but leaves lingering financial and emotional consequences ahead. It also highlights a critical lesson. When relationships and housing overlap without clear written agreements, disputes can escalate quickly and painfully. Verbal arrangements, shared living situations, and informal rent payments offer little protection once conflict arises. Now we turn the question to you watching. Do you believe the defendant was unfairly pushed out after years of shared life, or was this an overdue legal correction to a situation that had gone on too long without structure? Drop your thoughts in the comments. We want to hear where you stand. And if you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Until next time, stay informed, stay sharp, and we'll see you in the next case file.